Good evening, ladies and gentlemen. I, Major Jayesh Varma, once again welcome you all to this edition of Value Talks, where we'll be dealing with the questions of Armed Forces Tribunal, or rather, where we'll discuss with our panelist, who's a well-known advocate, Advocate Govind Bali, who's got a huge experience in dealing with armed forces cases and particularly Armed Forces Tribunal. So, talking about Advocate Govind Bali has been awarded with Nations Icon Award in 2022, as well as Icon of Asia Award in the same year. He is also founder partner of Fast Track Legal Solutions, which offers range of legal solutions in terms of criminal law, family law, divorce law, corporate law. So, welcome, Govind sir, once again at this platform.
Hi, good evening, sir. How are you, sir?
आई एम ग्रेट सर, थैंक यू वेरी मच. सो गोविंद सर, मैं शुरू करूंगा. आपका एएफटी का एक्सपोजर कितना है सर?
It's been some time, sir. Now I've been dealing with AFT. Other than AFT, I've also been dealing with the statutory and the non-statutory complaints that are filed in the armed forces. So
जी.
it's been quite some time because I've always been related to the army.
जी.
So it's been time, and the AFT is a good platform where justice takes place in a different manner because the tribunal is more favorable towards the soldiers at large, other than disciplinary cases.
Obviously, we will come on that aspect, but before that, was there any specific need to establish AFT when we have high courts, or is it because of the burden of long list of cases?
No, certainly there was a lot of need that AFT should come into place because, as we see, there is a central administrative tribunal, then there is a central electricity tribunal.
Sure.
So, with a branch of more than 12 to 50 lakh serving people in the armed forces, much more than that actually, taking into consideration the auxiliary armies and everything, there had to be an organization which was dedicatedly involved in resolving the service matters with respect to the armed forces. Not only armed forces, it is high time that we should come up with a tribunal even for the CAPFs because they are also having the similar service laws as the armed forces. And the more specific reason for coming up of AFT was because the army law or the martial law in general cannot be tried by a normal court. There are certain principles on which the army is based, and those ethos have to be understood by someone who has worked in the organization.
Understood. So, I mean, obviously, it is understood that it is for armed forces, but then what are the specific roles of AFT? What are the situations in which AFT doesn't entertain the cases of, let's say, service personnel or officers?
See, AFT has got simple rules, anything and everything to do with the armed forces, except from some exceptions. So you cannot go to the AFT for non-sanctioning of leave first. You cannot go to the AFT for your posting matters. If you have been posting from one place to another, you cannot go to the AFT stating कि मेरी posting आ गई है, मुझे वापस भेजो, because that is specifically covered under the Army Act. And the
Yeah.
Army Act talks about postings. The second is you cannot ask for tenures. Certainly, there is a ground of compassionatory ground postings, but that's a different topic altogether. So, in general, anything which is related to the personal, with respect to pay and allowances, with respect to disabilities, with respect to any kind of legal matters which have not been tried summarily against him, all of them can go to the AFT. So, basically, a summary trial cannot go to the AFT as such. So any punishment which is less than 3 months, the AFT will not entertain a petition against it. So that is why if you would have a look at it, the most number of cases in summary trials, the punishment is of 89 days, not of 90 days, because as soon as it becomes 90 days,
It
AFT
goes out of, yes, purview of. So, गोविंद सर, ये बताइए कि जैसे कि आपने बताया कि जो पर्सनल इश्यूज है, लाइक सैलरीज एंड पोस्टिंग्स, फॉर व्हिच एन ऑफिसर cannot go or a serviceman cannot approach AFT.
For salaries they can go.
Yes.
For salaries they can go, but not for postings as such. So there are very certain grounds on which they can go in case of postings. Also, that is specific to the compassionatory ground policies. So for that also, all three forces, actually all four forces, including even the Coast Guard, all of them have got the compassionary ground postings policy there, which is already in place, and there's a board which takes place for compassionary ground postings. So,
Understood.
other than that, in most of the cases, you can approach the AFT for your salary matters, for wrong pay fixations, for if you're not being given premature retirements, you can go and appeal that why the retirement should be given to you. I'm not talking about resignations, I'm talking about retirements.
Understood.
So other than that, as far as the fundamental rights are concerned, there are certain fundamental rights for which you can approach the High Court even after being in the armed forces, which is specific to the right to life. So, good example of that is in recent past, in around 2019 or 2020, some army officers, along with certain JAG officers, went to the Supreme Court, stating
Mhm.
that we should be allowed to use WhatsApp and social media profiles, in which
Understood.
the Supreme Court was very clear that you do not have the right to freedom of speech in specific. Your
Correct.
right to life is the only fundamental right which is specific to you, and we are getting that. Otherwise, you are, bound by the laws at large.
Understood. Understood. So, Govind sir, if you see most of the cases which reach AFT from service personnel are mainly related to promotions and disabilities. That is disability pension, you can say, or disability element. So, how and what are the things one should, do? What are the steps one should take before reaching AFT? Is it directly he can reach whilst in service, or he has to reach, after he retires, if he's retiring, or I mean, what is the exact procedure? What is the
So
ideal
basically,
procedure
what
to
the
approach
procedure
AFT?
is when we talk about AFT or any court. So
Sure.
before approaching the court, you should have exhausted all the remedies that were available to you before you have approached the court.
Okay.
So when we say that, the remedies would be internal complaints in case of the army,
Mm-hmm.
ROGs in case of Navy.
Mm-hmm.
Similarly, a stat or non-stat in case of Air Force. So when we talk about these, there is certain chain of command that exists in the organizations, like the army or maybe the Navy or the Air Force. All organizations have a chain of command,
Correct.
and there is a certain communication channel which exists there. Now, once you have exhausted all your remedies of communication and you've approached everyone, till the chief of army staff or the chief of air staff or naval staff,
Mm-hmm.
after that you can approach the AFT. Similarly, in case of disabilities, there is a procedure called first appeal and the second appeal. So,
Correct.
in case of the army, the first appeal goes to MP6, and similarly, it goes to similar counterparts in the other two organizations. In
Correct.
case of officers, with respect to other ranks, it goes to the regimental record. So,
Mm-hmm.
whatever regiment the individual is, he can just write to them that this is just the disability that I have had, and I want to appeal against it. And if they do not give a reply, then you can approach the AFT.
Okay. So to sum it up, you mean to say that whatever remedies are available, like in case of disability, there are appeal one, appeal two. So you have to exhaust that. But what happens if, if a particular service personnel is, applying or complaining or exhausting his remedies, but he's not getting the reply? So is there any time frame? Is there any time
For
period?
the first, for the first appeal, you'll have to wait in case of a disability. But after filing the second appeal, after a month, you should first send a reminder that you have filed the second appeal and you've not got any replies. And AFT in general is entertaining complaints or the disability petitions in which the second appeal's reply has not come to the petitioner. So it is clear cut a procedure that first appeal is a compulsion. So
Under-
generally, the time period for the first appeal is around 6 months. So, in some cases, what I have observed is people, while in service after their RMP, go for the first appeal.
Mhm.
But till the time the reply of the first appeal comes, they are already superannuated.
Correct.
So, basically, when they approach the court, they are already retired. So,
Yeah.
that means they approach the AFT after their retirement. In
Yes.
certain disciplinary cases, people approach the AFT during service. For
Mhm.
example, if you've been put in military custody or you've been put in a RI, you've been given RI in a military consolidation, or you've
Confined.
been given a red ink entry or you've been given a black ink entry, then you
Mhm.
can actually go down to the court, that is the tribunal, and say that this punishment that has been given to me is against the principle of natural justice. I was not given a clear chance to put my things forward.
Mhm.
Therefore, I am approaching this court while in service.
Correct, correct. So, is there? I mean, let's say, I mean, taking your example only, if before superannuating, if one is exhausting the remedy and putting, let's say first appeal, and he gets the answer for that after retirement, so what are the things before retirement, what are the documentations he need to keep with him, which will help him ultimately in the case? So is
So,
there any documentations which he needs to obtain from his last serving unit or place, or you can call it later on also, or what are the essential documents
so
which are required to
basically,
be
with
kept?
respect to the disability element that is concerned, your release medical board is the most important document
Correct,
because it is the RMB which decides whether you will be given the disability element or you will not be given the disability element.
correct.
But things in case of a battle casualty case are different altogether. Similarly, in case of a bias or in which there is certain vendetta in the organization against a particular individual, the case is totally different because in that you would need both circumstantial and documentary evidence to prove what the issue at large is.
Correct,
So you can only collect that data while you are in service in
correct.
case of vindictive nature in the organization because after you are released from service, after you are out of the service, the collection of data or the documentation becomes a bit difficult because then they bring in that it is the official secrets act to give replies. Then they say that they are not bound by the RTIs in certain manners, so the things become difficult. So in case of disability element, you can get the RMB's copy and fighting through the RMB in disciplinary matter is simple. It's not a
Understood.
very different case altogether. You have to have a relationship with the disability along with your service element. So when that service element is there, that service element has to prove that you had served in certain places, and while you came to the organization, you were shape one.
Correct.
So उसके अंदर भी बेसिकली क्या होता है कि जब हम ज्वाइन करते हैं तो हमारा एक कमिश्निंग या रिक्रूटमेंट मेडिकल बोर्ड होता है, तो वो रिक्रूटमेंट मेडिकल बोर्ड के टाइम का आपका कोई पुराना डॉक्यूमेंट जब तक ऑर्गेनाइजेशन को नहीं मिलता है कि आप शेप वन नहीं थे जब आपने ऑर्गेनाइजेशन ज्वाइन करी, तब तक दे कैन नॉट डिनाई द डिसेबिलिटी एलिमेंट टू यू until and unless in certain cases. Now there are certain cases which do not have any relations with respect to the military service at large. For example, one case was of tonic seizures, which was later on given to be attributable to military service. But in certain cases, the AFT has stated that it can be an autoimmune disease also. And it could be a
Understood.
disease that is by birth that you can acquire. So it has got no relations to the military service. But after certain landmark cases, even seizures have been now given as attributable to military service.
Same is with the issue with hypertension also. A lot of officers I have lately seen have been denied disability for hypertension.
See,
Now,
that is a wrong step that the MOD is taking or the pensioning authority is taking because hypertension in a lot of cases has been considered as a disability aggravated and attributable to military service. And there are clear wordings on that, not in one case, but in multiple cases, where it has been stated that an individual in the armed forces is staying in faraway areas where he's got no connection with his family.
correct.
He's facing tough terrains, he's facing tough operational and occupational hazards,
Mhm.
which actually cause the disability of hypertension. And another thing that I would like to add on this is that in a lot of medical cases, they state that the individual was posted to a peace station. Therefore, the medical condition is not attributable to military service. On that also, the courts are very clear. They have clearly stated that whether the individual was posted in peace or field is irrespective because a disease does not come overnight. A disease comes through a channel or a period of time. So in those cases, hypertension has been given the attributability to military service. The only bigger issue with the disabilities is of the issue of obesity. So in obesity, you do not get disability until unless your obesity is carried forward or actually acquired due to a disability which you got during the military service.
Understood. So there are few cases came into light where the RMB notified that it is attributable and or rather aggravated, whatever the disease is or the injury is attributable and aggravated. However, still the pension authorities have denied it and they have been forced to file appeal 1, appeal 2. So why such lapse? Why such things are first thing first happening?
Sir, it is failure of the pensioning authority, according to me, because once the medical authority has made it attributable and aggravated by military service, it should be given clearly to the individual. See, the life of an individual in the armed forces or any uniformed force is not that of a civilian or an individual who's not who's staying with the family. So the attributability, the organization which is the deciding authority for pensions should also be very careful when they are saying that it should be attributable and aggravated by military service. Second is the individuals who are conducting the medicals or the release medical boards should also consider the conditions in which the individual has worked. Now, there are certain cases that I have been fighting in which the individual has got a frostbite in the very first year of service, and it has been written that it is attributable to military service. But on
Correct.
the release, it has been stated that not attributable to military service. So,
Yes.
that means it is a failure of the organization which is conducting the, RMBs also. So, it is more important that the medical authorities at large come up with an idea of a uniform system rather than just putting non-attributable and having a clerical reply to all the disabilities. It is important that the military career of the individual should be taken into consideration.
करेक्ट गोविंद सर इसके साथ एक और मेजर इशू देखा गया है फॉर एग्जांपल इफ a particular officer or a jawan is having a category, I mean low medical category, and let's say his disabilities are in the tune of 40-45% at the time of RMB. However, whether it is attributable or not, his pension has been denied. When he files for a first appeal, then he gets a reviewed disability element reduced to let's say 20-25%. Is it firstly legal? Secondly, how and why people would do that? Because at the time of RMB, that officer or a jawan has been thoroughly checked and then the opinion has been made, and that opinion has been made by a board. But when you are applying or when you are giving a first appeal against the decision of the pensionary bodies, your disability element is getting reduced. How it can be possible? And is
So
it legal?
basically, the major difference is the pension issuing authority is not a medical authority.
Correct.
So, what the individuals who are issuing the pension are basically accountants. So, accountants cannot be good judges of the, which is called of the medical conditions at large.
Correct.
So, the individual who's giving that medical report that the individual is 45% disabled is the more and has got the better intelligence differentia when it comes to on deciding whether the disability is there or not, rather than an accounting officer. Further, during the regime of our defense minister, late Manohar Parrikar, MOD stopped going to the Supreme Court against
Correct.
the given of disabilities, but now they have again started. So it is basically, it is a political whim also that you have to be strong-willed about it, and even the hierarchy in the organizations has to be strong-willed that yes, if there is a disability, it has to be given.
Understood. Thank you, Govind sir. I mean, that is all the question I had.
You gotta focus on yourself, on your faith, on your dreams, on your mind, on your health, yeah. You gotta work, never tell, keep your head